Your concealed carry permit could become worthless paper in 37 days. 7 states are implementing new laws in January 2026 that will invalidate thousands of out-of-state permits overnight. If you are caught carrying with a canceled permit, you are facing felony weapons charges. Today, I am breaking down the 7 states that are canceling concealed carry recognition in January 2026 and which permits they are targeting. By the end of this video, you will know exactly whether your permit is still valid and what you need to do to stay legal. This is not speculation. These are signed bills taking effect January 1st. Gun owners in Florida, Texas, and Arizona are about to lose carry privileges in multiple states, and prosecutors are already preparing to enforce these new laws. One expired reciprocity agreement means you go from legal carrier to criminal the moment you cross state lines. Number 1, Virginia drops 11 Virginia non-resident permits. Virginia is canceling recognition for non-resident permits from 11 states starting January 1st. If you have a non-resident Florida, Arizona, or Utah permit specifically for traveling through Virginia, it is about to be worthless. Here is what happened. Virginia's Attorney General reviewed reciprocity agreements and determined that 11 states issue non-resident permits without requiring the same background checks Virginia demands under Virginia Code 18.238.014. The state can only recognize permits from states with substantially similar requirements. These 11 states failed the test. The specific states losing recognition are Florida, Arizona, Utah, Nevada, New Hampshire, Pennsylvania, South Carolina, Tennessee, Washington, Wisconsin, and Wyoming for their non-resident permits only. If you are a resident of these states with a resident permit, you are still good. But if you specifically got a non-resident permit from any of these states for travel purposes, Virginia will not honor it anymore. The consequence is immediate. If you are caught carrying in Virginia with one of these canceled non-resident permits after January 1st, you are charged with Class 1 misdemeanor unlawful concealed carry. That is up to 12 months in jail and a $2,500 fine. Your gun gets confiscated on the spot, and that misdemeanor conviction can prohibit you from owning firearms in other states. Virginia State Police have already sent bulletins to all law enforcement agencies about the change, and they are expecting to make arrests starting January 2nd when gun owners who do not know about the change try to carry through Virginia. Here is your solution. First, check if your permit is on Virginia's canceled list. Second, if you are a Virginia resident, apply for a Virginia resident permit immediately. Processing takes 45 days, so you need to start now. Third, if you are traveling through Virginia and your non-resident permit is canceled, you have 2 options. Apply for a Virginia non-resident permit, which Virginia still issues and costs $100, or avoid carrying in Virginia entirely until you secure valid documentation. Fourth, if you must travel through Virginia armed before getting a valid permit, know that Virginia allows open carry without a permit in most places. But that creates its own problems during traffic stops. But here's the bigger problem. Virginia is not the only state doing this, and the pattern is spreading fast. Number 2, New Jersey. New Jersey cancels recognition for 4 constitutional carry states. New Jersey is dropping reciprocity with Alaska, Arizona, Wyoming, and Vermont on January 15th, 2026. If you have a permit from these states and you have been carrying in New Jersey under reciprocity, that privilege ends in 36 days. New Jersey Statute 2396 requires that any state New Jersey recognizes must have permit requirements at least as stringent as New Jersey's. Since these states no longer require permits for residents, New Jersey argues there is no permit standard to compare. So recognition is canceled. Here is what makes this particularly dangerous. Alaska, Arizona, and Wyoming still issue permits even though they are constitutional carry states. They issue them specifically for reciprocity purposes. But New Jersey is saying those permits no longer count because the states do not require them for their own residents. Vermont has never issued permits at all. So Vermont residents have always had problems with reciprocity. But Alaska, Arizona, and Wyoming permit holders thought they were covered. Not anymore. The stakes here are brutal. New Jersey has some of the harshest gun laws in America. Getting caught carrying without valid reciprocity is a secondary crime. Under New Jersey law, that is 5 to 10 years in prison and fines up to $150,000. New Jersey prosecutors do not negotiate on gun charges. Last year, a Pennsylvania gun owner spent 7 months in jail awaiting trial because he did not realize his permit was not recognized during a traffic stop in Camden. His bail was set at $75,000. His gun was permanently seized and he eventually pleaded guilty to a third degree charge just to avoid the maximum sentence. His legal fees exceeded $40,000. Your action plan starts now. If you travel through New Jersey, stop carrying there immediately unless you have a New Jersey-issued permit. New Jersey is a may-issue state with extremely limited issuance. Assume you will not get one unless you are connected or have documented threats against your life. Second, if you must travel through New Jersey with a firearm, transport it unloaded, locked in a case, separate from ammunition in your trunk. That is the only legal way to transport through New Jersey without a permit under federal safe passage law. Third, consider alternate routes. Drive around New Jersey if possible. It adds time but eliminates felony risk. Going through Pennsylvania or Delaware adds maybe 45 minutes to an hour, but it keeps you out of New Jersey's jurisdiction entirely. And this pattern of canceling constitutional carry state permits is spreading to more states than just New Jersey. Number 3, Maryland terminates Florida non-resident permits. Maryland is specifically targeting Florida non-resident permits starting January 1st. If you got your Florida non-resident permit because it was cheap, easy, and had wide recognition, Maryland just made it illegal to use there. Maryland reviewed Florida's non-resident permit process and determined it does not meet Maryland's training requirements under Public Safety Code 52306. Florida requires a basic firearm safety course for non-residents, but Maryland demands 16 hours of instruction, including live fire qualification. Maryland's Secretary of State sent official notice to Florida in October 2025 that the agreement is terminated. Florida non-resident permits have been popular for years because Florida issues them to anyone from any state who completes a basic course. You do not have to live in Florida. You do not have to visit Florida. You just take an approved course and mail in your application with $117. Tens of thousands of gun owners have Florida non-resident permits specifically because they were recognized in 38 states. Maryland just dropped that number to 37 for non-residents. Getting caught carrying in Maryland with a now invalid Florida non-resident permit is a misdemeanor with up to 3 years in prison and a $5,000 fine under Maryland law. But here is what makes this worse. Maryland charges this as wearing and carrying a handgun, which stays on your record permanently and can trigger federal firearm prohibition under certain circumstances. A Baltimore defense attorney told me he has already seen 3 cases this year where out-of-state carriers did not know their permits were not recognized. All 3 were convicted. All 3 lost their guns permanently rights entirely because of prior misdemeanors on his record. Here is how you stay legal. First, if you have a Florida non-resident permit and you carry in Maryland, stop immediately. Second, Maryland still recognizes Florida resident permits. So, if you are a Florida resident with a Florida resident permit, you are fine. Keep documentation proving residency with you at all times. Carry a utility bill, lease agreement, or Florida driver's license as backup proof. Third, if you are not a Maryland resident and need to carry there, apply for a Maryland non-resident permit. Maryland is now a SHASU state after recent court rulings, so the process is easier than it used to be, but it still takes 90 days and requires that 16-hour training course in person. But the non-resident permit problem goes deeper than just Florida. One state is banning all of them. Number 4, Delaware ends all Delaware non-resident permit recognition. Delaware is taking the most extreme step, canceling recognition for all non-resident permits from every state on January 1st. It does not matter if you have a Utah, Arizona, Florida, or any other non-resident permit. If it says non-resident on it, Delaware will not recognize it. Delaware's Department of Justice issued guidance in November 2025, stating that Delaware will only recognize permits issued to actual residents of the issuing state. Their reasoning is that non-resident permits do not prove the carrier has ties to a specific state's legal system or training standards. Delaware Code, Title 11, Section 1441, gives the Attorney General authority to determine which permits qualify for recognition, and they have determined non-resident permits do not meet the standard. This affects a massive number of gun owners. Utah alone has issued over 700,000 non-resident permits because they are easy to get and recognized in most states. Arizona has issued hundreds of thousands of non-resident permits. Florida's non-resident permit program is one of the largest in the country. All of these are now invalid in Delaware starting January 1st. The penalty for carrying with an unrecognized permit in Delaware is a Class D felony up to 8 years in prison. Delaware prosecutors have wide discretion on gun charges, and they routinely seek maximum sentences for out-of-state violators to send a message. I researched Delaware court records and found 14 cases in 2024 where out-of-state gun owners faced felony charges for permit violations. None of them knew their permits were not valid. The average sentence for those convicted was 18 months in prison, and every single one of them lost their firearms rights permanently. Here is your 3-step fix. First, if you have any non-resident permit and you travel through Delaware, assume it is invalid starting January 1st. Second, if you are a resident of a state that Delaware recognizes, make sure you have your resident permit, not a non-resident one. Delaware publishes a list of recognized states. Verify your home state is on it. Delaware currently recognizes resident permits from 22 states. Third, if you must travel through Delaware and you are not from a recognized state, do not carry. Transport your firearm unloaded and locked in a case in your trunk. Delaware allows locked transport under federal safe passage law as long as you are just passing through without stopping except for fuel or emergencies. And the constitutional carry states are facing even more restrictions beyond what we have already covered. Number 5, Connecticut refuses to recognize constitutional carry. Connecticut is implementing a new rule on January 1st that effectively bans carrying for anyone from constitutional carry states who does not have a physical permit card. If you are from a constitutional carry state and you are carrying in Connecticut based on reciprocity, you are about to be illegal. Connecticut's Department of Emergency Services issued a bulletin in September 2025 clarifying that Connecticut General Statute Section 29 to 28 requires a valid permit or license for reciprocity. Connecticut's legal interpretation is that constitutional carry authorization where no permit is issued does not count as a permit or license. You must have an actual physical permit card from your home state for Connecticut to recognize you. There are currently 29 constitutional carry states in America. That means residents of 29 states can carry in their home state without any permit at all. But many of those states still issue permits on request specifically for reciprocity purposes when you travel. Connecticut is now saying if you do not have that physical permit card, you cannot carry there. Even if your home state is on Connecticut's reciprocity list, this creates a trap. If you are from a constitutional carry state like Texas or Alabama, and you carry in Connecticut without a physical permit, you are committing a Class D felony. That is up to 5 years in prison and a $5,000 fine. Connecticut State Police have already started training officers on this new interpretation, and they are preparing enforcement operations at highway rest stops near state borders. Getting caught means your gun is seized. You are arrested on the spot, and you are facing a felony that will end your gun ownership rights. Connecticut does not mess around. They will prosecute and they will seek prison time. Here is what you do immediately. If you are from a constitutional carry state, check whether your state still issues physical permits even though they are not required. Many constitutional carry states like Ohio and Georgia still issue permits on request specifically for reciprocity purposes. Apply for one now. Processing takes 30 to 60 days depending on the state. Second, if you travel through Connecticut before you get your physical permit, do not carry. Transport your firearm locked and unloaded in your trunk. Third, keep a copy of Connecticut's reciprocity list with you so you can verify your permit is recognized if you are stopped. Connecticut State Police are known for pulling over vehicles with out-of-state plates, especially from gun-friendly states, and checking for weapons violations. But it gets worse. Some states are canceling recognition mid-year without giving you time to prepare. Number 6. Illinois announced in December 2025 that they are suspending reciprocity with 8 states starting January 1st while they conduct comprehensive permit standard reviews. Those states are Tennessee, South Carolina, Oklahoma, Kentucky, Indiana, Missouri, Arkansas, and Louisiana. Illinois says the suspension is temporary, but they have not given an end date. Illinois did the same thing in 2019 with 4 states, and 3 of them never got reciprocity back. Illinois used the suspension as a way to quietly drop recognition without officially canceling the agreements. What changed in these 8 states? Most of them reduced training hour requirements or eliminated live fire requirements to make permits more accessible. Tennessee dropped from 8 hours to 6 hours. Oklahoma started allowing online training. Kentucky eliminated the shooting test. Illinois is using these changes as justification to suspend recognition, but the real reason is Illinois wants to make it harder for gun owners from other states to carry there. Carrying in Illinois with a suspended permit is aggravated unlawful use of a weapon, a Class 4 felony. That is 1 to 3 years in prison and up to $25,000 in fines. Illinois prosecutors are aggressive on gun charges, especially in Cook County and the Chicago area. Illinois law allows vehicle seizure. If you are arrested for weapons violations, your car can be impounded and sold at auction. I found cases where gun owners lost $30,000 vehicles over weapons charges because Illinois seized and sold their cars before the cases even went to trial. Here is your emergency plan. First, if you have a permit from any of these 8 states, stop carrying in Illinois immediately on January 1st. Do not wait to see if reciprocity gets restored. Assume it will not. Second, if you travel through Illinois regularly for work or family, consider applying for an Illinois non-resident permit. Illinois is a shall-issue state now after court challenges, so you can get one if you meet the requirements. But expect a 120-day processing time and a 16-hour training course requirement that costs $200 to $300. Third, if you must drive through Illinois without a valid permit, use the federal safe passage provision. Firearm unloaded, locked, inaccessible, and you must be traveling through without stopping except for gas or emergencies. If you stop for lunch, shopping, or anything else, you are violating safe passage and you can be arrested. And the final state on this list might surprise you because it is usually gun-friendly and pro-Second Amendment. Number 7, Pennsylvania drops 5 states over training requirements. Pennsylvania is canceling reciprocity with South Dakota, North Dakota, Kansas, Mississippi, and Idaho. On January 10th, 2026, Pennsylvania reviewed these states' training requirements and determined they do not meet Pennsylvania's standard under Section 619 of Chapter 18 PACS. Here is the specific issue. Pennsylvania requires live fire training for permit issuance. These 5 states either do not require live fire training or allow online courses to satisfy training requirements. Pennsylvania's Attorney General sent formal notice in November 2025 that these states' permits will no longer be recognized starting January 10th. Pennsylvania State Police will begin enforcing the change immediately. South Dakota and North Dakota both allow online-only training with no shooting requirement. Kansas reduced its training requirement to just 2 hours with optional shooting. Mississippi allows applicants to substitute a hunter safety course for firearms training. Idaho accepts any firearms training certificate without verifying live fire components. Pennsylvania says none of these meet their standard, so recognition is terminated. Getting caught carrying in Pennsylvania with one of these canceled permits is a first-degree misdemeanor, up to 5 years in prison and a $10,000 fine under Pennsylvania law. Pennsylvania has mandatory minimum sentencing for gun crimes in certain counties, particularly Philadelphia and Allegheny County. That means if you are convicted, the judge has no choice but to impose prison time. There is no probation option. The mandatory minimum is typically 2.5 to 5 years, depending on the specific charge and your criminal history. Pennsylvania is also one of the few states where getting arrested for a gun violation can affect your ability to get hired in certain professions. Pennsylvania does extensive background checks for teachers, healthcare workers, and government employees, and weapons charges, even if dismissed, show up on those checks and can cost you job opportunities. Here is how you protect yourself. First, if you have a permit from South Dakota, North Dakota, Kansas, Mississippi, or Idaho, mark January 10th on your calendar and stop carrying in Pennsylvania after that date. Second, check if your home state is still on Pennsylvania's recognized list. Pennsylvania still recognizes 28 states, so your resident permit from another state might work. Pennsylvania publishes an updated reciprocity map every quarter. Third, if you live in Pennsylvania or travel there frequently, get a Pennsylvania permit. Pennsylvania shall issue for residents and has a straightforward application process taking about 45 days. The application fee is $20 for residents, and you need to complete an approved training course with a live fire component. Expect to pay $75 to $150 for the course. That is the January 2026 reciprocity map. Make sure you are legal before you cross any state line. And if you need updates the moment laws change, subscribe to Weapons Law Advisor right now so you never get caught off guard again.